In the meantime, the federal government is seeking to enhance the implementation of social protection programs in Nigeria. The protection policy is structured along 4 pillars of social assistance, social care, social insurance, and labor market interventions in order to alleviate poverty. But there are gaps across projects with no interaction platforms in the MDAs for efficient implementation. Consequently, the Federal Ministry of Budget and Economic Planning has set out to establish a community of practitioners for the social protection actors across the MDAs for the implementation of the National Social Protection Policy.
The Federal Ministry of Budget and Economic Planning has set out to establish a committee of practice for the social protection actors across the MDAs for the implementation of this policy. This COP will provide a platform to discuss progress, share knowledge and skills, enhance information exchange, as well as track the status of implementation of the policy in respective MDAs. It's worthy to note that the establishment of the COP will not end at the national level, as implementation of the social protection resides mainly in the subnational levels of government. It will be part of the mandate of the COP to ensure that the COP is replicated in the states, as it will facilitate progress of social protection implementation at that level. I wish to inform this meeting that a dashboard on the social protection will be established in the ministry for a real-time information on the policy and activities. This will be made possible through the information and data that will be fed into the database by members of the Committee of Practice. I wish to formally inaugurate the Committee of Practice on the implementation of the National Social Protection Policy and wish you fruitful deliberations.
The Ministry of Communications, Innovation and Digital Economy has pledged to work with the National Assembly to strengthen Nigeria's data protection laws in line with international best practice. Communications Minister Bosun Tijani said this at a sensitization workshop on data privacy and protection. Now, while emphasizing the importance of prioritizing the implementation of strong data privacy laws, he says the workshop is part of efforts towards strengthening Nigeria's data protection framework. Meanwhile, the National Commissioner in the Nigeria Data Protection Commission says the meeting will provide stakeholders with an in-depth understanding of the country's data protection laws.
Embrace age, it is crucial that the personal and sensitive information of our citizens is maintained under the highest standards of confidentiality. We're committed as a government to ensuring that every Nigerian can trust the digital platforms that they use, knowing that their personal data will not be misused or mishandled. To achieve this, however, we are taking proactive steps to strengthen our data protection framework, as evidenced by the setting up of the NDPC. We're working with all stakeholders, including the National Assembly, towards the enactment and implementation of robust data protection laws.
What kind of technology can we use to actually drive compliance in this country? Indigenous solutions, not imported solutions from different places. We have the people, we have the knowledge here, so we need to develop homegrown solutions that can assist in compliance. Then sustainability and funding, which I already mentioned. A major challenge for DPS all over the world is the issue of funding. But we've adequately taken care of that in our law. And we don't really encourage any problem. The partnership and collaboration, which is really key, as I mentioned during my speech, that this is something that no single entity can do it. We all need to work together.
Now, the National Commissioner of Nigeria Data Protection Commission, Vincent Olatunji, joins us to have a discussion on this. Thank you very much indeed for coming to Newsnight.
Thank you for having me here.
Now, let's begin with the data subjects. My primary concern, like most Nigerians anyway, would be how data collectors and data processors can fulfill their obligations to data subjects. How can we ensure this?
I think it's very straightforward, and that's the whole essence of having a law in any country.
Right.
If you don't have a law, you think you can collect data and do whatever you like with it. But in Nigeria, as we speak, we have a national law for data protection in the country. And what the data processors and controllers need to do, basically stated out in the law. One, they need to have a privacy policy, which is clearly written, and for anybody to be able to read and understand in a very simple way. They should have their DPOs, not like the police station, data protection officers in this case.
Right.
The workshop that we had today and yesterday, it was mainly for data protection officers from various ministries, departments, and agencies. Three, to employ the services of data protection compliance organizations. These are licensed experts who work on behalf of the commission to take organizations through compliance. They look at your governance structure, they look at your availability of a DPO, your data processing activities, and whatever you do in the area of data protection. And your privacy policy, that will actually give information about who you are as an organization, the kind of information that you collect from data subjects, how you process such data, how you store such data, safeguards that were put in place to secure such data, and your contact address, where you work, and your social media
Handles
and
and what
so
have you.
so that
Yeah,
in
characters.
case of any issue, we can easily contact you. And you are supposed to submit all this to us. In fact, that is the next stage of this law. Since the law has been passed, the next stage is for data controllers and data processors in Nigeria to register with the commission, so that we'll be able to know those who are even regulating and monitor them on a regular basis. And on an annual basis, they submit their compliance report to us. Two things. One, if there is any major issue, for instance, a breach, the first thing we look at is your data compliance report, which we already submitted to us. In the case where we don't have that, it makes the issue very serious. That means you've not be compliant with the law. I'm pretty sure. But if you comply, anything can happen. There can be accidents at any time. But the case where we don't have your compliance report with us, there will be serious issues. So the next stage of this law is for us to register all data controllers and processors to go through their data processing activities, to look at what they're doing and ensure that they put in place appropriate safeguards to protect your data and my data with them.
What are some of those appropriate safeguards that you expect the data controller to actually put in place? What will you be looking out for when they bring this reports to you?
Mainly, they are categorized into two.
Right.
One is called the technical measures, and the other one is organizational measures. Now, under the technical measures, you talk of the kind of software you deploy, the kind of database you are running, the kind of firewalls that are put in place, the type of antivirus, all the things that you put in place to secure the data in your database. The other one speaks about your privacy policy, which I already mentioned, the competence and the capacity of your staff in charge of data processing activities. What kind of knowledge of data processing do they have? Do they have appropriate knowledge to ensure? For instance, you go to a bank, you see long exercise books with names, telephone numbers, even account numbers, boldly written. Anybody can just get there, snap such, and start making calls to customers of banks. Bank officials, for instance, do they know that they don't even have to keep that book anyhow? And there are even some register that you keep that where you write, nobody sees it. It's only the bank that will see what you have there. These are some of the measures that you need to put in place, which are not technical. The knowledge of your staff, your privacy policy, your privacy statement, the look and feel of even your online presence. All these are things you need to put in place to ensure that anybody that is coming to your website or to do business with you, know, mere seeing that, you know that yes, you have put in place some measures to protect such data with them.
Now, how do you ensure that personal data are processed in a fair, lawful, and accountable manner? Because I'm bothered about what anybody does with my data.
Yes, I'm happy that even the way you put it, fair, lawful, and transparent manner. Now, we have some rights as data subjects, but do you know your rights? Other people, do they know their rights? That is where we have a lot of work to do to create awareness. In the sense that before your data is collected, the first thing that they need is your consent.
Right.
Because now we want to collect your data for A, B, C, D purposes. We're going to use your data for A, B, C, D purposes. are you willing to still release the data to us? And it has to be affirmative, yes or no. Yes, I'm giving my data. 2, the right to be informed. That is, they need to inform you for what purpose they are collecting that data, how they are processing it, how they are sharing it, who they are sharing it with, how are they storing it. Are they even sharing with a third party? Are they sharing across to other countries? That is beyond Nigeria. All these are things that they need to inform you. Right of access. If your data is with any data controller, at any point in time, you have the right to access such data to ensure that your data with them is accurate. Right of erasure. So it's okay, I'm no more doing business with you. Please erase my data completely from database. That is your right. Right of refusal of profiling, automatic profiling. Now, for instance, blockchain, AI, all these emerging technologies, I don't want my data to even be processed through this means. You have all these rights, but how many data subjects know these rights? And that is why we're going to do awareness consistently on the part of the data subject to know what they should ask for if anybody is asking for data, and on the part of data controller and processor to know that there is that duty of care, that accountability, which is really key. You are held accountable for the data of any Nigeria in your custody. These are things that we need to create awareness. For instance, what we did today.
Let's simplify it for the average Nigerian, so it's not too technical. Right, we know that the president signed the data protection law in June, of this year. Does the data protection, does it repeal the Nigeria data protection regulation of 2019? And how much of a game changer really is it? I mean, how significant is this law?
Now, the Nigeria data protection regulation is still existent, because if you look at part 12 of the law, where we have sections 63, 64, 65 to 66, we call it miscellaneous provisions, stating that all the things, all the documents, the properties, the staff, everything of the Nigeria data protection, the then Nigeria Data Protection Bureau will now be inherited by the Nigeria Data Protection Commission. Now, there are some investigations that are already going on under the NDPR. If you repeal it immediately, what happens to that? You can't apply this law, the current law, retrogressively. You still have to use the NDPR to prosecute the cases you have started under that. And there's some other things too that are still useful to us under the NDPR. So they are still working on that. Not until we are able to get to a level that's okay, NDPR, you've lived your time out, we charge you, we don't need you anymore. Now, what we need to do is to look at both of them, weigh them, anyone that we think is still apply for any sector or for any particular case, we use that, and then if there's another one, the second question was about...
Yeah, the point as to how significant, signing this particular act
now,
is.
We were using a regulation before.
Right.
A regulation is not as powerful as a principal law. The regulation was a subsidiary legislation to the Act of 2007. It's different from having a principal law on data protection for the country. Yes, there are some observations, some lacunas that we noted in the regulation, and some of those were able to take care of in this present law. For instance, even the issue of compensation to data subjects in case of any breach, that was not properly taken care of in the regulation. That has been taken care of in the law, and that we have the right to even press for charges, and we can even recommend recommendations on behalf of data subjects whose data have been breached in one way or another. And so many other things that we've noted that like shortcomings in the regulation, which we have adequately taken care of under the law. And because the law went through a very long, you know what it takes to pass a law in Nigeria, engaging with stakeholders alone. We did that for almost 8 months. So it really took a lot of time, engaging stakeholders, talking to private sector, public sector, multinational, especially on the issue of cross-border transfer of data. If you are moving your data from Nigeria, what safeguards do you have in such countries? There is this adequacy principle. Are you sure that those countries, they have their data protection laws, DPAs, what certification, what safeguards do they have? All these are clearly taken care of in this.
Fantastic. That's good to know. Vincent Olatunji is National Commissioner, Nigeria Data Protection Commission. Thank you so much for joining us.
Thank you for
on
having
Newsnight.
me.